two people from the Matlin Law Group. Eric Matlin, who's the founding partner of Matlin Law Group in Northbrook, he's concentrated his law practice on estate planning for over 25 years. He's helped thousands of families achieve their planning goals by delivering quality representation with an emphasis on transparent process and pricing. He educates people about the importance of estate planning, speaking to those who know they need it, but don't understand its urgency, as deadlines pass without advance notice. A critical takeaway from his first book, 2004's The Procrastinator's Guide to Wills and Estate Planning, with a new edition come out this year, is that since many of his life's most momentous events are not calendar entries, the time to plan is now. In 2019, he published a book, Not Dead Yet, So Plan Your Estate is a serious estate planning handbook. And with him is Jeff Ramirez, who's senior associate attorney at the Matlin Law Group. He also devotes his practice to estate planning, estate and trust administration, guardianships, and corporate law. He works closely with the clients to create an estate plan that captures the client's values while also providing guidance on the transfer of wealth between generations. As a client advocate, he represents individuals, families, and businesses in estate and trust matters. He earned his BS with honors from DePaul University in accounting and a minor in economics. Thereafter, he attained his Juris Doctorate degree from DePaul and was admitted to practice law in the state of Illinois. I could go on and on. These guys have got tremendous qualifications, but I think you want to hear from them. So I'm going to turn it over now to both Eric and Jeff. Welcome, guys.
Thank you. Thank you. Jeff is going to present the PowerPoint presentation, and I'll chime in from time to time too.
Thank you so much for having us today. We're very happy to be here. So today's presentation is going to be an overview of estate planning, kind of what's the purpose, what's the goal behind an estate plan, what are some considerations that you should have when discussing estate planning or starting the process of determining, what is the best estate plan for me. I'm also going to talk into a little bit about some of the two most common court proceedings and court procedures that most clients will encounter, and how estate planning helps to avoid and mitigate those two general court proceedings. So just by way of introduction, here at the Matlin Law Group, we're a dedicated 7-attorney group of attorneys that specialize in all estate-related matters. The goal here for our team is to get to meet with you, get to understand what your family's needs are, and for us to kind of plan an effective strategy. We understand that every family has a different set of family dynamics. So our goal is to understand that and help you plan for situations that may occur during your lifetime, like an incapacity, or transfers of assets to your intended beneficiaries, whether they are individuals, whether they are other outside family members, or even charitable organizations. So since we practice in a wide area of estate planning matters, we're able to really provide a very comprehensive planning with our clients. We take care of estate planning from A to Z. We help clients in the beginning stages of formulating an estate plan, all the way through possible guardianship matters if a client were to become incapacitated, and even post-death planning, right when we're either in an estate administration or a trust administration. However, the overarching goal here in an estate plan is to capture your thoughts and your goals in writing in a very clear and effective manner. The primary philosophy here at the Matlin Law Group is that everyone benefits from an estate plan, regardless of wealth. It doesn't matter if you've got a couple $100,000 or several $1,000,000. Everybody needs a estate plan, and everybody benefits from having powers of attorney, from having a will, or even a trust. So the point here is that we're able to service clients, doesn't matter your wealth. So here we're going to talk about the beginning stages of what's the goal of estate planning and why does it matter. So I'd like for you guys to think about estate planning as a planning opportunity. It's an opportunity to control your assets. It's an opportunity to plan your fiduciaries and pick them. It's an opportunity to determine how you want to transfer wealth to your intended beneficiaries, whoever those may be, or charities. And it's an opportunity to perform any kind of tax planning. So you want to take these things into consideration, and it's important to do so while you still have capacity. The other benefit of having an estate plan is the efficient administration of assets. It's by writing down your goals, by having it clearly outlined in a document, whether it's powers of attorney for healthcare and property, or a will, or a trust. Having a plan that is clearly defined, that outlines who your fiduciaries are, how are my assets managed during my lifetime, and ultimately, how are they distributed to my children or loved ones. Having that plan in place and having that clearly outlined makes the whole process that much simpler and avoids having to either go into court through a guardianship proceedings or having to go into for a probate matter. The other good aspect of an estate plan, of having an estate plan, is you're able to control how your beneficiaries receive assets. Maybe in situations where I'm planning for a family with minor children. There's some specialized planning that we need to have for them. We can't just give them money. We have to set up and nominate guardians, and we've got to set up specialized trust funds for children that are minors that under Illinois law cannot just outright receive money. So the point is that it allows us to put some controls in place depending on your particular situation. Another example of control to beneficiaries is we like to utilize child separate trusts or beneficiary separate trusts in our planning documents. This allows us to give assets to either your children or the next generation, but in a controlled fashion that allows them to gain money over a period of time. And the idea is that as they mature, as they age, they're better able to manage their own finances. In other situations, it may make more sense to maybe not give them that particular beneficiary control for a number of reasons. Maybe they're just not good with finances. Maybe they have an underlying substance abuse issue, or any other risk factors that the creator of these documents has a concern for. They want to provide for this individual. This individual, for whatever reason, just cannot be allowed to manage the money or finances. The other and fourth main point of why an estate plan matters is for private administration of an estate. Clients that have powers of attorney for healthcare and property, that helps to keep them out of guardianship court, which we're going to dive into very briefly in a moment. That going into court is automatically opens the door to the public process, to the public eye, to seeing into your assets, your estate. They get to know who your family are, and they get to know the value of your assets. By creating these documents, by creating an estate plan, it helps to mitigate those chances of that ever happening. And it's really the documents that control the distribution of assets, and that helps to keep it out of the public eye. So next, I'm going to go into the two most common types of court proceedings. The first proceeding is a guardianship. Now, guardianships is a court supervised process where the court appoints an individual. It could be a spouse, it could be a child, it could be a family member, or it could be a friend. This court proceeding is reserved for situations where the person, for whatever reason, whether it's due to an accident, whether it's due to a health issue, that they are no longer able to make decisions for themselves. They cannot make healthcare decisions. They cannot make financial decisions on their own. In situations where clients do not have powers of attorney, which help to avoid guardianship, the family members are left with their only option is to go into court to nominate somebody to act as guardian for that person. The guardianship process in general is very intrusive. It opens the door to the person's finances in certain situations, and it opens the door to declaring somebody as basically incapacitated by the court. So you lose all sense of privacy, and the process in and of itself from start to finish can be very expensive. Just to give you a brief overview of how the guardianship process works, it starts off by a petitioner filing a petition in guardianship to appoint themselves as guardian. Upon receiving the petition, the court then on its own appoints a guardian ad litem, which is simply an attorney that is the eyes and the ears of the court. They go out to the family to investigate whether a guardianship is appropriate or not, and to raise any potential issues that they may see. Once the guardianship is established, on an annual basis, there's going to be annual reports that are going to be due by the guardian. These annual reports basically provide a healthcare summary and a healthcare update to the court. In addition to the healthcare updates, there's also an inventory of the person's assets as well as a budget established and annual accountings every single year that the guardianship is in place. So as you can see, this is a very intrusive, a very public process, and anybody can search the court records and be able to look up these guardianship estates. So the second type of most common court proceedings that I come across in practice is called probate. So probate is the process where, again, it's a court supervised process that basically the court then determines who the heirs at law are or admits a will into probate. So here in the state of Illinois, there's a threshold for probate. Whenever a person passes away, if in the name of that person, if that person has more than $100,000 worth of assets, that automatically subjects the estate to probate. What's key here to point out is that there are certain types of assets that are excludable from probate. Okay, so assets with designated beneficiaries, like you would find on a life insurance policy or 401k policy. Assets held in joint tenancy. The most common type is in a husband and wife situation where they own their principal residence by tenancy by the entirety with rights of survivorship. Those help to avoid probate. Assets with payable on death designations, very commonly used on bank accounts. So the goal here is, in an appropriate estate plan, an estate planner will consider each and every one of your assets to determine whether your estate may or may not be subject to probate, and will be able to implement certain planning strategies like a will or a trust to help mitigate this probate process. In probate, just like in guardianship, it is a very public process where you're submitting to the court an heirship of your family, so they're going to know who you're married to, who the decedent was married to, what their heirs at law are, who their children are, and ultimately who the beneficiaries of the probate estate are going to be. So the goal here in any estate plan is to avoid the probate process as much as possible.
Jeff, I just want to underline that every day there's people that go down to the Cook County Court, 12th floor, and they bring their tablets, they bring their computers, and they download all the public information. So that includes all the contact information of the beneficiaries, including what they're receiving. If you've been a private person your whole life, why would you want to open your estate up for any kind of examination to people who may be trying to sell your beneficiaries some products or other nefarious activities? They'll at least be getting more junk mail. Who needs it? Always try to stay out of court. That's a major item. And I only want to, I just don't know when to jump in and out, Jeff, because he's following this. I also want to mention that the last type of, and I'm giving it up early, but the last type of way to avoid probate is to own your assets in a trust, because when you think about it, a trust doesn't die. It just continues until it exhausts its assets. So that's one of the things that Jeff's going to talk about. But I just wanted to underline, stay out of court whenever you can, during your lifetime, during incapacity, or upon your death. Thank you.
Thanks, Eric. Those are great points. The other thing with probate is that it delays the administration of assets to your intended beneficiaries. The court process, the process in and of itself, at least forces us to wait at least 6 months before any distribution to beneficiaries can be made. Whereas in a trust structure, distribution can happen a lot sooner. So there's not only a delay, but it's just adding hurdles to your loved ones, whether it's a surviving spouse or whether it's a child, for them to be able to administer a person's estate efficiently and effectively. So now we're going to start getting into the different types of planning documents that we use in our practice, and I think it's important to understand, what are we planning for? So during our lifetime, we're planning for a period of incapacity. The likelihood, I guess the last statistic that I've heard out there was, 60% of us at some point are going to be incapacitated, whether it's simply going through a medical procedure or due to an accident or due to an illness of whatever capacity. We have a high probability of there to be an incapacity. And during that period of incapacity, we don't want to lose control or access to our funds. There's nothing more frustrating for a family member and a loved one trying to take care of a person, and that's either in the hospital or maybe in the middle of a crisis, and not being able to access funds to continue to take care of that person, whether it's for a medical procedure, maybe it's for rehab, maybe it's for placing the person into some sort of an assisted living or memory care facility. It's already stressful enough for a family to have to grieve and have to emotionally deal with the incapacity, but then also to add a layer of complexity to that, to be able to access finances. And the other planning opportunity that we're planning for during our lifetime is to pick your fiduciaries. Pick the people that you feel are the most in line with your wishes, are the most in line with following through with your goals. And you're able to pick those individuals and make sure that they're the ones that are actually making your decisions for you. The goal of any post-death planning is, which I'm referring to as a will or a trust, is again to maintain that level of privacy. A trust is like a contract. The terms of the trust control the use of your assets during your lifetime, and then at passing. Only the parties to the actual contract, they're the underlying beneficiaries named in the trust, have the right to get a copy of the trust, have a right to know what the assets are that are owned by the trust. Any other outside third party must request permission from the beneficiaries. They do not have an outright access or are privy to this information. The other planning opportunity here is as I briefly touched upon previously, is about control over distribution of funds. Depending on your particular situation, every family has different family dynamics, but most clients like to control the distribution of money, especially when they have children that are either minors or are young adults. Also, another big opportunity here is what if you have an individual that is either receiving public benefits, maybe they're receiving Medicaid and receiving funds through a trust, is very possible, but there's a specific way in how we have to do it. If we don't have that structure in place, if they just receive an outright distribution, they may have to give up those public benefits that they may be receiving at that time. And the final most planning opportunity is tax planning. Here in the US, we've got two planning structures that I typically work with my clients on. We've got the income tax structure, which most everyone is very familiar with. That's when we file our income taxes every year, on our US 1040 income tax return. But the other system that I'm concerned with as an estate planning attorney is the estate tax. There's both an Illinois estate tax and a federal estate tax. So depending on, when I'm sitting down with clients, depending on if the value of their assets are at or exceed, or maybe in the next few years they're going to exceed these limits, it's important that we incorporate some tax planning into their documents, so that way their hard-earned assets are not being given to the Illinois Department of Revenue or the IRS, or at the very least, we're helping clients to minimize that tax exposure.
Hey, Jeff, can I jump in? I just want to mention that since we're talking about powers of attorney, every single person that's listening to this seminar should have powers of attorney, and that includes even your children, your grandchildren. Anybody that's over the age of 18 should have a healthcare power of attorney to avoid a guardianship of the person. I talk a lot about the 3 a.m. call from the parent from the college where a child is away and hurt themselves, but they can't give any information. The parents lose control at age 18 because the child is an adult, has a right to make their own decisions, and has a right to privacy. There's no, without a HIPAA authorization, the parents can't even find out what's going on with that kid in college. So there's that. And then there's also the financial power of attorney. Again, it's such an easy document. And to avoid all those things that Jeff talked about upon incapacity during your lifetime, who knows if you'll ever need it, but you sure do need it when if somebody bangs their head and they lack the ability to give consent, because it just throws your life open in court and costs dollars to hire attorneys to go into court. So I just want to say, entry-level estate planning, everybody needs powers of attorney. Here's Jeff.
Perfect. That's a great segue into our next section here, which is we're going to be talking about the powers of attorney. So a couple of the documents that we use during our lifetime is, besides the powers of attorney for healthcare and property, is HIPAA authorization. So the purpose of a HIPAA authorization is for the release of medical records to whoever you've named under the documents. Typically, I like to name whoever you're naming as your fiduciaries under the documents. I like to also name them under the HIPAA authorization. Now, the power of attorney for healthcare. So the purpose of this document, as we've alluded to previously, is you're naming an agent. You're naming somebody to make medical decisions on your benefit in the event you become incapacitated. The agent's going to have the power to make decisions for you regarding treatment, regarding possible placement into a rehab or a nursing home facility. They're able to meet with doctors and try to evaluate the most efficient or caring plan that proposing. And they're even able to make, the most difficult decision here, which is, pull the plug, so to speak, in terms of, when the person is in a terminal situation and there's nothing that can be done. There's no medical treatment, there's no procedure that can be done, and you're basically left in a vegetative state. That at that point, that very hard decision is very difficult for a family or loved one to make. The healthcare power of attorney helps them in the sense that it outlines what your wishes are, whether your wishes are to be like, to say, no, I do not want to be kept alive by artificial means. You're right that we disclose that in the form. Or the alternative is if you do want to be kept alive no matter what. So by putting that in the document, it alleviates the stress. It alleviates the family member that's in charge of having to make that decision, and it really makes their job a lot easier. And you get to select your agents. Sometimes you may want to choose maybe whether it's a surviving spouse or maybe it's a particular child that has a better skill set, like maybe they're a doctor, maybe they're a nurse. So you're able to pick your order of fiduciaries, again, to make sure that that your wishes are being followed and that you've been able to nominate somebody that you know is going to follow through and is the best suited person to be making these healthcare related decisions. The next and final planning document is the power of attorney for property. This is naming an agent to make financial decisions on your behalf. So the agent here is going to be allowed to make any and all sorts of financial decisions. My general power of attorney for property encompasses a wide range of different transactions. As a firm, we've also specialized and we've added unique provisions to our powers of attorney that sets our powers of attorney apart from other firms in the sense that we've added language regarding trust funding. We've added language regarding digital assets. Now that our world is very digital, almost everything is online, whether it's bank accounts, social media accounts, you name it, it probably has some sort of an online digital footprint. The other thing is we've also added language for gifting. Maybe spouses are covering gifts to their children, whether it's medical expenses, whether it's tuition expenses, maybe they're in college and they need to cover some living expenses. So all of these unique specialized provisions are all included in our documents that help. Again, the goal here is to be very comprehensive and to cover any possible future situation that a client may encounter. With the powers of attorney for healthcare and property, these two documents are what help you to avoid guardianship. If you step back and think about it, guardianship is here for when clients do not name agents to make healthcare or financial decisions for them. With these two documents in place, you're able to avoid that process. You're able to keep your affairs private, and you're able to name the individuals and the family members that you want to take over and manage your property and to manage your finances and your healthcare decisions. The most common example of a typical situation that I personally have encountered in practice is a situation where, let's take, for example, a married couple that they're either in their mid 80s to early 90s, where they're dependent on their children to help them with paying bills, with managing their finances, with driving them to doctor's appointments, with making medical decisions for them. And let's say both of them or one of them become incapacitated because their children have been able to be making decisions for them during this whole time without powers of attorney for healthcare and property. That's putting them at a disadvantage because the moment mom and dad become incapacitated and there's no powers of attorney for healthcare and property, that's going to cut off the lifeline that they've been receiving from their children in managing their affairs. So in order to make that transition, to document that transition and to give them the legal authority to continue to make medical and financial decisions, it is absolutely important and critical that we've got these documents in place so that way we're not caught up in a situation where either mom or dad are both become incapacitated and their children or other family members cannot get access to their finances to continue to take care of them or to even make medical decisions. At that point, the family's only option is to go into guardianship. And like we've discussed in the past, it's a very intrusive, it's a very public process, and it just only adds to the level of stress and the amount of anxiety that now, unfortunately, the family members have to go through in order to continue to do the job that they were already accustomed to doing. So it's a huge efficiency and a huge money saver if you have, at a bare minimum, have these powers of attorney for healthcare and property in place. Now, a lot of questions that I get about powers of attorney is, if I sign a power of attorney, does that mean I'm signing my life away to my named agent? And the answer is no. There's two types of powers of attorney. There's an immediate power of an attorney, which means the moment you sign it is the moment the agent that you named in the document immediately takes control over whatever the power of attorney is, whether it's finances or whether it's healthcare. A springing power of attorney, also known as an advanced directive, that's where you execute a power of attorney today. You still have full capacity. You still make your own decisions. It's only when sometime in the future, again, we don't know when that's going to happen, but if it does, the document will spring into action, and your agents, whoever's listed under the documents, will then now start taking over whatever fiduciary responsibilities they have to do. So the next two documents are what I like to call them as post-death planning. They are, the first document is a will. So a will, which is a big misconception in estate planning, and I get this question asked a lot in practice, is I have a will, I don't have to go to probate. My family doesn't have to go to probate. That's good. I've outlined who gets my assets. And that's just not the court procedure. That's not the process. So a will is nothing more than just a declaration of your intent on how you want your assets distributed. A will is not a separate entity. You don't transfer assets into the will. A will just indicates how you want your assets to be distributed upon passing. So in situations where we've got clients that only have a will, that's not sufficient enough to avoid probate, because whether you're in probate or not strictly depends on whether your assets are at the time of passing are at $100,000 or more. So the will, even though it's an important document, to be fully effective, and in most situations for most clients, a will is usually combined with a trust, because the trust offers us that extra level of planning. And because a trust is treated as a separate entity, we can transfer assets into trust, which allows us to avoid the probate process. So when it comes to talking about trusts, there's all sorts of different types of trusts that you're going to see out there. There are revocable trusts, there are irrevocable trusts. There's life insurance specialized trusts. There are trusts for clients that have special needs, like supplemental needs trusts or special needs planning. So, but by far, the most common type of trust that we typically set up for our clients are called revocable trusts. These trusts operate during your lifetime. This is a trust where you're able to transfer assets into this trust. It's treated as a separate entity, and it survives you. Even after you pass away, the trust continues to live on. A unique feature of a revocable trust is that you're able to make changes over time. Even though you create the trust today, and let's say 10 years from now, maybe 5 years from now, circumstances have changed that you need to make changes under the terms of the trust. Terms of the trust contain the provisions are, how is the trust property used during your lifetime? What happens if you become incapacitated? It also has incapacity provisions within the trust. And then it ultimately provides for what happens if I pass away. In certain situations, we form joint trusts between couples. Some situations, due to tax planning, we need to set up different separate trusts. The point here is that a trust allows us to have a lot of flexibility here in how we draft the document, so we can clearly capture whatever your goals are, whatever however you want your assets to be distributed, whether it's to a person, whether it's to extended family members, whether it's to charities. We're able to encompass your goals and objectives within the trust documents. It also allows us to set up any type of specialized planning. If you want to set up education trusts for your grandchildren, we're able to incorporate that into your planning. If we need to set up spendthrift planning for individual beneficiaries that should not have control over money, we can set that up as well. A very common type of planning that I'm seeing more and more often in practice is special needs planning. So individual beneficiaries that are currently receiving public aid, or maybe they're receiving some other type of form of governmental assistance due to a disability or due to an incapacity. That if they were to receive money without incorporating some sort of a special needs planning into the trust document, that would disqualify them and put them at a financial burden, not only to themselves, but whoever's there taking care of them. Another very common planning that we've typically, that I'm seeing more of is we can also set up pet trusts. Like, for example, in a couple situation where they both pass away and they've got pets. Oftentimes our pets become like our family, and we're able to segregate, who's going to take over, custodial rights, so to speak, for the pets. And then some clients like to put a couple $1,000s aside, $5,000, maybe $10,000 aside, so that way whoever's taking care of the pets does not become a financial burden to them.
Jeff?
Oh, yes, Eric.
I'm just going to expand a little bit on revocable trusts. A grantor revocable trust is kind of like a financial alter ego. You completely control it. It's not a tax entity during your lifetime, so that the tax ID number of the grantor revocable living trust is generally your social security number. There's no difference in how you use the money during your lifetime. You spend it, you gamble it, you give it away, you invest it, whatever you want to do with your trusts. What the trust does, it's the overall shell of your estate plan. It's often the heart of your estate plan, and all the sub-trusts flow from the revocable trust. And I just want to also mention, just because I know we're waiting till the end to give comments, I did see that Ron sent a group text that sometimes it's better to have a probate because you cut off creditor claims potentially. And my pour-over will, a pour-over will is a will that just leaves all your probate assets to your trust. My probate, my will says that I direct my executor to do a nominal probate so that I could cut off any creditor claims that would come from children of a disgruntled beneficiary somewhere in the future after I'm gone and can't defend myself anymore. Well, in that case, a probate is helpful. And in fact, I did, or I do, because a will is not effective until I'm dead. I do direct a probate in my estate, but it's a very small and managed probate. So I just want to put that out to everybody. And the revocable trust, if you ever want to change it, it's easy to change. And it's unfortunate that the name is revocable, because really it's a changeable trust. Let's say your life goes upside down and you get remarried, you have more kids, you restate the trust. But once you have a revocable living trust and you title your assets in the name of that trust, you're never going to want to revoke it. You could just restate it, which is kind of like an amendment on steroids. But all the revocable trust is, it's your financial alter ego that you completely control. You don't have to involve banks. People think of trust, they think of banks. It's just your financial alter ego. Continue, Jeff.
Thanks, Eric. Yeah, no, absolutely. And I think to your point on the probate situation, that's absolutely a consideration that we have whenever we're doing an estate administration. We sit down with our clients and understand, what are the inventory of assets? What are the outstanding creditors? And to the extent it makes sense from an efficiency standpoint, from a cutting off creditors point of view, and from a financial standpoint, if we do need to do a probate, even though a client has a trust, we'll absolutely consider that as a strategy in order to cut off creditors. So that's a great point. So here I've just outlined some of the top 5 questions that I typically see in practice that are asked by my clients. So the first question is, what's the difference between a will and a trust? A will is, again, just to summarize, a will is just a statement of intent. It's not a separate entity, and it just merely states how you want your assets to be distributed upon death. A trust is a separate entity. It allows you it operates both during your lifetime and after death, and it is the cornerstone piece of most estate plans, in the sense that it contains all of the distribution procedures and provisions in that document. A trust is like a contract. A trust is not made public record. When somebody passes away and they have a will is filed within the county in which that person resides in, whether it's Cook County, Lake County, DuPage County. In our wills that we draft, we don't like to put any specific information besides the name of the person, obviously the creator of the will, as well as who the named executors are. But we like to minimize and not try to put any personal information or list who the beneficiaries are. In most cases, we do what's called a pour-over will that just says, transfer upon my passing, transfer all of my assets to my trust. Contains no other language regarding who the underlying beneficiaries are. In a trust, it's completely private. Only the parties to the trust, the creators of the trust, the grantors, or the underlying beneficiaries have a right to receive a copy of it, or are entitled to an accounting. So that's a key distinction there. And we utilize a trust in order to hold the assets that would not otherwise pass probate. Typically, it's real estate, and typically it's bank accounts and brokerage accounts. Assets with designated beneficiaries, we just ask that we work with our clients to make sure that those are filled out appropriately. Both primary and contingent beneficiaries are filled out. The next question I get a lot is, I have a will. So does that mean I get to avoid probate? And again, the answer would be no. In a case where you only have a will just dictates and states, what you want, how you want your assets to be distributed upon passing. A will is an important document, and it works really well to alter the Illinois default rules. So in Illinois, for example, when you have a probate estate, one of the very first questions that they're going to ask you when you're filling out the petition for probate is, do you have a will or do you not have a will? So if you don't have a will, then you're subject to the Illinois default rules, which is called the rules of intestacy. Okay, under the rules of intestacy, a really common an example of this would be in a husband and wife situation. Okay, let's say that each of them don't have any wills. Okay, husband dies. Okay, one would assume that my spouse gets everything, but under the Illinois default rules, that's not the case. Upon the passing of the first spouse, the surviving spouse, assuming they have children, gets only 50%. The other 50% is distributed equally amongst the then living children. So in most cases, in a married couple situation, that's usually not the way that married couples would like their assets to be distributed. They almost assume that my assets will go to my surviving spouse, and that's just not the case. Having a will does help you to avoid those default rules, because under a will, you're able to name who your beneficiaries are. But because a will is not treated as a separate entity and doesn't have a separate tax ID number, and you can't transfer assets into your will, a will not avoid probate. It's just a document that I typically present to a judge in a case where I do have just a will, where I tell the judge, we have a probate because we've got more than $100,000 worth of assets here, and here's the will, and here's who the beneficiaries should be pursuant to the will. The next question that I get is, if I retitle my assets into my trust, do I lose control? And as Eric just alluded to, one of the key features of a trust is no. You are generally the trustees of the trust. The person creating the trust is their own trustee. So even though assets are retitled in the name of the trust, which is done for avoiding probate and assisting in the transfer of assets to your beneficiaries, you are the trustee of your own trust. So you retain full control over the trust property. You can still access it, you can use it, you can you can mortgage it, you can transfer it, you can sell it. There's no restrictions whatsoever. The trust also dictates that all of your trust assets are to be used for your benefit, whatever you dictate that to be. So it'll cover all of your living expenses, healthcare, maintenance, best interests, whatever you need to have to use the trust property for, you're able to do so. So there's no restrictions whatsoever. The next question that I get a lot is, if I transfer my assets into trust, am I protected from creditors? So the general answer to this question is no. Typically in a revocable trust situation where the trustee is both the creator of the trust and also the person in control, for creditor protection purposes, because the trustee maintains control over the trust property, and you're wearing both hats. You're the trustee and the beneficiary together. You don't necessarily have creditor protection, and transferring your assets into a trust doesn't necessarily protect you from that. However, if you were to, for example, set up trust for your children, what we typically like to do is we like to set up what's called child separate trusts, where upon the passing of both husband and wife, my children receive their share in what's called a child separate trust. Within that, that child has the ability to nominate a person other than themselves, so that decouples the trustee and the beneficiary. Under those circumstances, although it's not 100% certain, it provides for us a layer of creditor protection, and it makes it that much more difficult for creditors to order a trustee who's not the beneficiary of that child separate trust to gain access over the trust property and direct those assets to be used to pay off whatever, whether it's a lien, whether it's a judgment against that particular beneficiary. The other benefit reason why we use child separate trusts is that it helps to protect the child's inheritance. A very big part of my concern for clients are what happens if I leave a huge inheritance to my child gets married, and now they, for whatever reason, no one likes to think about it, but what happens if there's a divorce? Does my inheritance have to be split with their spouse? And the key to that under Illinois law, if they commingle their assets, then absolutely at that point, if they commingle their inheritance with their marital assets, that will be subject to division by the court, usually 50-50 or whatever the court orders. But if they're able to keep it segregated, keep it in this child separate trust, which by default we usually counsel our clients to do, then that offers them an opportunity to keep it separate from their marital assets. So if that unfortunate situation were to ever come up, then they're able to completely protect their inheritance and not have to share it with their respective spouse or soon-to-be ex-spouse. And the final question, the final combination I get here, which I know we've already touched upon, that is, in a revocable trust situation, you're absolutely able to make changes. The document is designed to be flexible. is designed to grow with you and your family, and allow you to make changes along the way. If circumstances change, you're able to do what's called a restatement and modify the language of the trust depending on your family circumstances. So just to start to wrap things up, I got a few, concluding remarks here. And just want to highlight and reiterate the fact that, you don't want to wait till it's too late to write down your goals and final wishes. The opportunity to prepare an estate plan is while you have capacity. The moment you lose capacity for whatever reason is the moment you lose that opportunity to get your wishes in writing. And it's the planning process is emotional. I can't tell you how many times I have clients in my office that, they've been putting this off for such a long time. I understand. No one likes to talk about, talk about death, talk about passing, and it's a difficult subject. But it's important to get your wishes in writing, because that opportunity is while you still have capacity. You don't want to be in a frenzy or in a crisis situation where you lose that opportunity, and now your loved ones, either your surviving spouse or your children, are now running around having to, consult with attorneys such as myself in guardianship or possibly probate, because an estate plan was just never done by their parents. And regardless of your net worth, everybody benefits from from having an estate plan. And we offer different types of packages of estate planning for clients that just want powers of attorney for property and healthcare. We've got a plan for you. If you would like to have, if your estate needs a trust or two separate trusts for tax planning, we're able to accommodate your needs as well. So we really offer a wide spectrum of planning opportunities to help assist you and your family, and that's one of the benefits of working with us, and as a firm, we the philosophy here is that everybody should have an estate plan. So here's our contact information. I'll open it now for any questions or comments, but if you need to either send us an email afterwards, here's our email addresses. If you would like to give us a phone call, both Eric and I would be more than happy to sit down with you and talk to you about any concerns or any specific questions you may have after the meeting today. And just wanted to thank everybody for your time. And it's been a pleasure presenting before you.
Thank you. Jill, may I just spend 2 minutes on just what it's like when the client calls?
Oh, sure, absolutely.
Okay.
And then I'm sure Jay's got some comments to make as well.
Okay.
And there's a few questions in chat.
Okay, well, we get a phone call. I need an estate plan. I don't know if we need a trust or not. Okay, so what we do is we schedule our initial estate planning consultations are always free. Okay, we spend an hour, give or take, with somebody. I enjoy educating, as I've got the 2 books, The Procrastinator's Guide to Wills and Estate Planning, 2021 version. And I also have Not Dead Yet, So Plan Your Estate, which includes the cartoon. So your kids might enjoy it too, and maybe you would too. But we book a meeting. We do have a flat fee brochure for anybody that wants to know ahead of time, what are they going to pay for something like this. But I enjoy just educating, whether they hire us or not. We find out about the family dynamics. Let's say a 1 hour meeting, the first half of it, or wherever that line is just who are the players? What's everybody's contact information? Who gets along with who? Who do we have to watch out for? Later on in the meeting, we get into money. Let's say we have a meeting of the minds. We say, okay, this is what you're going to do. This is the estate planning package that, about 90% of our clients go into a flat fee. They're all custom documents. That doesn't mean that we create them from the get-go, but now we've got a meeting. Let's say it's Zoom, telephone, in person. After an hour, we say, okay, this is what you need, what we think you need. They hire us. About a few weeks later, they get a draft. We schedule a meeting to go over the draft. If there's any changes at that point, then we go through that. We recompile the documents with the changes. We send them back, and that exchange process could go one or two or more times. Once we get that meeting of the minds, then the client schedules a meeting. They come in and sign. They walk away from here with all the original documents, a full set of copies. We send a PDF to them if they wish, so that they could forward to their kids. We send a copy of any trust to their financial advisors, who we like to be part of a team of financial advisors, accountants, attorneys, and all the meetings that come later, there's no cost to them, because we just want our clients to feel that they're getting what they want in terms of peace of mind, because that's all we sell is peace of mind in estate planning. So I just wanted to put that in there. The initial consultation's always free, and we do quality work.
Thank you so much. Really
Yeah, so-
appreciate this, and I'm sure that our audience appreciates everything that you put forth. Thank you so much.
Just very last question. Sorry to take up one last question. Does Illinois tax non-revocable trust for grandkids? Can you do it for grandkids?
I don't understand the question.
It says from Ken, does Illinois tax non-revocable trust for grandkids? So is there a
Oh.
tax for
If
non-revocable trusts for
Yeah, there's-
grandkids?
It might be a 2503C trust. There's a special kind of trust. It's a gift tax trust that you often might give to grandchildren, or a 529 plan. Any of those. There's certain things that can that are outside the tax area. Yeah.
Right. Well, thank you very much. Thank you, Jeff. That was a wonderful slide presentation. Thank you, Eric, for all the words of wisdom. And thank you, everyone, for coming. I see hands clapping, I see waving, but I don't see any other questions. Thank you, everyone, and see you next time.
Thank you. Bye-bye.
Thanks so
Bye.
much. Have a
Bye.
great day.
You too,
Bye.
everybody.